Okay, welcome everybody to the Expungement 101 webinar this afternoon. Thanks for being here. This is going to be our Expungement 101 training. So this is going to serve as our comprehensive introduction to Maryland's expungement law as of the year 2025. And we'll be going over a little bit of legislative updates as well. So I'll get started and jump into the presentation. All right. So, as I mentioned, this is going to be a presentation about the criminal record expungement laws of Maryland. MVLS helps our clients expunge those records of criminal offenses that occurred at the state level in Maryland. So, we do occasionally get questions about out-of-state charges or even federal charges. We do not advise clients on the law as it pertains to that, but we try to perhaps find a referral to a group in another state that they might be able to call. And as far as federal, there is not much of a process that exists, but we can only really refer our clients elsewhere to seek help with that. So just a little bit of background about why do we need expungement? What exactly happens when someone gets arrested, gets a criminal record, and then files for expungement. So the way that things work in Maryland, if someone is ever charged with a crime, they basically have a permanent, publicly visible criminal record that can be found by landlords, employers, and other entities that may impact that person's ability to find stability in life, to find employment, to find housing. So even if the person is never convicted of any of the charges, they still may very well have a publicly visible criminal record. There is some automatic expungement, but it only applies to dropped charges that occurred after October 1st of 2021. So anyone who had an arrest prior to October 1st, 2021 is not going to have their charges ever disappear from public view, even if they were found not guilty or had those charges dropped, without proactively going forward and filing for that expungement. So when someone seeks expungement, when the court grants that request based on the filing of the petition, what technically is happening is the court is ordering the expungement of those records, and it serves the order upon different state agencies that have touched the record along the process. So when you think about the arrest, the police department creating their own report, creating their records of that event, then the prosecutor is getting their own case file, the court clerk has the case housed in that system. There's fingerprinting agencies, criminal justice reporting agencies. So the court is ordering all of those agencies that created that paper trail to get rid of the record, any record that they have of that event. And then the case is essentially treated like it never happened. There's a very little room for anyone to be granted access to an expunged case. Certain entities like law enforcement may be able to make that request, but they would have to get special permission from the court. And the reality is, most of the time, the records are going to be largely destroyed once the expungement actually goes through. Okay, so this slide is just a snapshot of really the zoomed out view of what expungement looks like in Maryland. This is, in a sense, almost everything that you need to know from a very broad view about the way expungement works in our state. And on the left and right sides, you can see that the slide is divided into two different statutes. So this is Criminal Procedure 10-105 and 10-110. So those are the primary statutes that we deal with when we are looking at expungement eligibility. 10105 primarily deals with cases that did not result in a conviction. And then 10-110 deals with most of the convictions that are deemed eligible for expungement, but with the extra requirements of waiting periods and free from subsequent convictions and other things that we will get into. So before moving on and digging into these categories a lot deeper, just a quick overview of 10105. Generally looking at cases that did not result in a conviction, they can almost always be expunged with very little exception. The offense charged in the case of a non-conviction is almost never relevant to expungement eligibility. The only time a specific crime is singled out in 10105 to be made a little harder to expunge is driving under the influence. And we'll get into the specific requirements for that. There's a couple of low-level convictions that are dealt with in 10105. Cannabis possession convictions, which now have their own sort of world of expungement, and then nuisance and transit offenses, which have 3-year waiting periods for convictions. We'll get into the details of that shortly. And then convictions is, again, its whole separate world with its own rules, which we'll be diving into. But before moving forward, I want to mention the unit rule that you'll see highlighted at the bottom of the screen there. So this is one of the most important things to remember for the way expungement works in Maryland. So the unit rule states that all charges in a case must be eligible for expungement in order for that case to be eligible for expungement. So in other words, if a person has several charges in one case that resulted from the same incident, the same arrest, same overall event that led to the arrest, if they resulted in multiple charges, and let's say they had 5 charges, 4 of them were dropped, if that 5th charge does result in a conviction for something that's not eligible for expungement, then the entire case is not eligible for expungement. So keep that in mind as we're learning the requirements for eligibility, that we always are talking about cases where every charge in that particular case does meet the eligibility requirements in one shape or other. Okay, getting started on the expungement of non-convictions. So starting at the very bottom in terms of the simplest outcomes, the simplest eligibility requirements, the easiest types of cases to expunge. So these on the left-hand column are potential outcomes or dispositions to criminal charges that are not convictions and generally are not going to require any additional things being ordered by the court that the defendant has to do. The defendant is generally walking away from that court case with nothing left to be done. Except in the case of being transferred to juvenile court, of course, the juvenile court takes it from there. But if someone receives a null pros, acquittal, or dismissal on all their charges, this is the best outcome, of course, for the defendant in that moment, and it's the best outcome for expungement eligibility. So these can all 4 of these dispositions can be expunged right away. There is no rule that a subsequent conviction at a later date is going to block it. There's no waiting period. The only prerequisite is that if the person seeks to expunge the case within 3 years
of that disposition date, they must file with the expungement petition a waiver of all claims that they may have against the state, the police department, or any party to that prosecution. So that could also include the victim as well. The reasoning behind that is that the state's position is if someone were to expunge their criminal case and their statute of limitations has not yet run out on any civil claims that they may have related to the event, such as a civil rights claim, if that person were to turn around the next day after receiving the expungement and file a civil lawsuit against the state or the police department, then the state would have potentially destroyed the records of what happened in the event, and so would not be able to defend itself properly against that lawsuit. So that's the underlying policy behind the requirement of this waiver. And so it's good to know the reasoning behind that in order to properly advise clients about what exactly they are signing and agreeing to if they seek to expunge a case that is less than 3 years old. So that is as simple as it gets in terms of Maryland's expungement laws. Again, these are outcomes of a criminal charges that result in the ability to pretty much expunge the case right away, no questions asked. And so moving on, we'll be kind of climbing the ladder in terms of adding on more requirements and more complications to the eligibility requirements. So we're still in Criminal Procedure 10-105. We're still talking about non-convictions. These are two dispositions that are a little bit elevated beyond just a null pros where the charge is getting dropped, or of course an acquittal where the person is being found not guilty. These are outcomes to charges which may carry some requirements that the defendant has to comply with. It's not technically being considered a guilty finding on paper, but these are things where perhaps the defendant has been cooperating with the prosecution. Generally, we're seeing lower level offenses, nonviolent offenses, and perhaps this person doesn't have an extensive criminal record or wouldn't be considered danger to the public, and they'd be given the benefit of these dispositions. So a stet is basically an indefinite postponement of the prosecution. And so the prosecutor is deciding we're not going to pursue these charges, but we're not formally dropping them and entering a null pros. We're just saying we're going to wait, give the defendant the benefit of not continuing with the prosecution, not actively seeking incarceration or any other direct punishment at this time. However, the prosecutor retains the right for 3 years to bring those charges back. Within the first year, they can bring the prosecution back for any reason. Within years 2 to 3, they must seek permission from the court to re-prosecute. This would generally be done if the person is found to have been arrested again. And so for a stet, if someone receives a stet on their charges, this is a pretty simple one. They must just wait out that 3 years and then they can expunge the case. So there is nothing that would block the case from getting expunged, such as getting a new conviction within those 3 years, as long as the stet remained the disposition. It's just a straight 3-year waiting period. So then probation before judgment is very similar, but has a slight complications. So probation before judgment, again, may be given in the event of even maybe a plea deal, where the defendant is taking a plea deal where they are not going to end up getting a conviction entered on the record, but perhaps they've been cooperative, perhaps it's a low-level offense. So now they're getting a disposition on their charge known as probation before judgment. This is often given in the event where the court actually accepts the guilty plea, finds the person guilty, but then strikes that finding and enters a probation before judgment. However, there's abundant statute and case law that pretty firmly comes down on the side that even though that may technically happen on paper, a probation before judgment is not intended to count as a conviction for any purpose, for any other punishment or consequence that might flow from a criminal conviction. The legislature's intention is that a probation before judgment not be considered a conviction for any reason. So if someone has that case on their record, they technically must wait 3 years from the entry of the probation or the date that the probation ended, whichever of those two periods is longer. I have pretty much never seen a probation that ends up being longer than 3 years. Of course, that is possible. So you do want to double check the case. But as a shorthand, you can generally consider these to be 3-year waiting periods. I think I might have seen a probation be longer than that once. There's an additional requirement on these PBJs, which is that the person must be free from new convictions within 3 years, within the 3 years of the disposition date, or during the duration of their probation. So a new conviction within 3 years will make the previous case ineligible for expungement unless the subsequent case does end up getting expunged. And then there is this exception for driving under the influence. These were largely, for many years, completely ineligible for expungement, even if you got a PBJ. They are now a 15-year waiting period. Same subsequent conviction rule applies, and also getting another PBJ for a DUI will block the expungement from occurring. I believe it's the second DUI within 15 years will extend for a second 15-year period, and then a third one will permanently block them all from getting expunged. And so going over to the right-hand column here, this is sort of just an illustration of the unit rule and how you have to stack sort of the requirements when analyzing a case, and always analyze based on whichever disposition has the most stringent requirements for expungement. So if you have a mixed case where someone was given 3 different charges, 2 of them were dropped, received a null pros, and the third count had a stet, this is because of the unit rule. The analysis turns on the count 3, the stet. So even though a null pros would be immediately eligible, because it's part of a unit with a charge that received a stet, you must go to the rules for stet, and that person must wait the full 3 years before they can expunge that case. So another way you can think about it is you cannot expunge individual charges. You can only expunge a case, unless, of course, there are exceptions to that rule, which we will get into later. All right, so we are still in Criminal Procedure 10-105, and we're talking about the minor low-level convictions that are dealt with in that statute. So this statute deals with these crimes that are deemed nuisance crimes as well as transit offenses. And these are enumerated fully in the statute.
But things like public urination,
panhandling, sleeping in public, loitering, and then offenses that have to deal with breaking the rules on public transit. So these are not driving offenses, these are public transit offenses. Skipping out on payment, eating, drinking, sleeping on transit. Um, these, if found guilty, just again have a straight 3-year waiting period. There is no subsequent conviction rule for those offenses. And again, if it's just a dropped charge or what have you, you would analyze that based on the specific disposition. But if it's a conviction, under 10105, you have eligibility after 3 years from the date of disposition. So then we have cannabis is dealt with in 10105 as well. And I do have a slide that's specifically about cannabis coming up later in the presentation, but as a little preview, there's actually 2 provisions that allow you to expunge cannabis possession. So just possession itself. 10105 has convictions for acts that are no longer considered a crime. And then it also calls out cannabis possession specifically, which is just now made eligible. So the technicalities of this would basically just be turning on the amount of cannabis that the person had. But now that recreational cannabis has been made legal, the amount in question would basically be so high so that you can more or less get eligibility under Act No Longer a Crime in the vast majority of cases. There's also, and again, I'll go into more detail about cannabis on a later slide, but under 10105, Act No Longer a Crime, there is also a couple offenses that were decriminalized over the last couple years, which are now made civil offenses that would fall under this provision. Those would be certain types of open container violations and sort of street level gambling offenses, which you sometimes see come up on someone's record with the charging language gaming slash cards slash dice, etc., is what it would show up as. So if you do see that, you want to always go back and double check the specific statute that someone was charged with. But keep in mind, if you see something like gambling or open container, it might actually be considered a civil offense now and could be expunged as Act No Longer a Crime. So Act No Longer a Crime and cannabis possession convictions, these have no subsequent conviction rule, and they can be expunged without any waiting period as well. All right, we're now jumping over to expungement of convictions, the big list of eligible offenses. This is found in Criminal Procedure 10-110. So the way that this statute works is it's just an extremely long list of specific crimes found on the books in Maryland, and it deems them potentially eligible for expungement and then separates them into different waiting periods, more or less based on the severity of the offense. And it sets out some extra requirements, which are basically a subsequent conviction rule, which we're now familiar with from probation before judgments. But it works a little bit differently for these convictions. So on the left are just a brief snapshot of what we have seen to be the most common offenses that we are expunging when it comes to convictions. So it's really not possible to memorize the full list, but it is found in the statute. The statute, perhaps a little unhelpfully, just cites the statute numbers where those offenses are contained.
On our website, mvlslaw.org, we do have those statute numbers matched to the actual
charges, so that you can view that and compare your client's record to that list of offenses. And so, like I previewed here, on the right-hand column, these are the basic requirements before someone can expunge a case where they were found guilty and that particular crime that they were convicted of is deemed possibly eligible. And we'll get into more detail about the subsequent conviction rule on the next slide. So as you saw on the previous slide, there are these 5, 7, and 10-year waiting periods for expunging convictions that are deemed eligible under 10.110. So basically, misdemeanors are a 5-year waiting period, the only exception being second-degree assault, which is a 7-year waiting period. And second-degree assault is generally deemed a misdemeanor. Like I said, there's really no way of memorizing the full list, but you can sort of think of this as generally low-level, non-violent offenses, generally misdemeanors. If you're seeing that on someone's record, you should be thinking, okay, this sounds like a pretty minor thing. It may well be on that list found in 10.110, and then you want to go looking for it. If it is something that is like sounding pretty egregious, a crime of violence, anything involving weapons, it's not going to be found on that list. So the vast majority of felonies are not expungible if the person's convicted. There's actually only a very small handful that are pulled out, and they fall into that 7 and 10-year waiting period. So those are drug possession with intent to distribute, third-degree burglary. These are both felonies that fall into the 7-year waiting period. And then felony theft, first and second-degree burglary are in the 10-year waiting period. So those are the only felonies that are possibly eligible if found guilty. And I do want to call out CDS possession with intent to distribute. This is a separate offense from CDS distribution, which is not eligible under the current law. So if you see someone charged with, it often comes up looking like manufacturing, distribution, or dispensing of CDS, controlled dangerous substance. That charge is not eligible for expungement. It is different than possession with intent to distribute, which is eligible with this 7-year waiting period. So let's talk about those requirements in more detail. Again, there is a subsequent conviction rule, and the person cannot be convicted of a new crime within the waiting period. And we'll talk about what happens if that does occur. But before going into detail on that, it's important to understand the waiting period for these offenses under 10.110 begins when the sentence ends. So the waiting periods on the STETs, the probation before judgment, that begins at the date of disposition. These waiting periods begin when the person finishes the sentence. So that includes any incarceration, probation, parole, supervision. All of that has to be over, and then those 5, 7, or 10-year waiting periods start counting down. So what happens if someone does get a subsequent conviction? If the subsequent conviction is not eligible, then it permanently blocks the previous case from being expunged. If the subsequent conviction is eligible for expungement, then you have to wait out that subsequent conviction's waiting period before you can expunge either case. So in a sense, it restarts the clock. Or another way you could look at it is you have to wait out whatever the most recent conviction is, and then that's going to be holding back previous convictions where it fell within those waiting periods. And then everything becomes expungible all at once the most recent one becomes eligible. And so the statute doesn't require that you expunge them one by one going backwards. It's written so that when the most recent one becomes eligible, everything becomes eligible. And so let's look at some examples of how that works. So example one, you have someone in 2010 was convicted of CDS possession with intent to distribute. Again, that's a felony, 7-year waiting period. They got 2 years of incarceration, so they finished their sentence in 2012. So then they have to wait out 7 years from 2012 in order to expunge. That means they're waiting until 2019. Now this person got convicted of misdemeanor theft in 2018. They were given 1 year of probation. Now the 2018 case is now blocking the 2010 case from being expunged because this person has to wait until the 2018 case is eligible. That means they finish their probation in 2019, they add 5 years from the completion of probation, and that case becomes eligible in 2024. Now both cases become eligible in 2024. In example two, this is a mix of convictions and non-convictions. So if in 2015 this person was convicted of felony theft and was given 2 years of incarceration, so they complete their sentence in 2017, they would have a 10-year waiting period. So they have to wait until 2027 and have no new convictions in order to expunge the 2015 case. This person got arrested and charged with disorderly conduct in 2018, but it was put on the STET docket. So that doesn't affect the 2015 case at all because it's not a conviction. But this person was then convicted of robbery in 2020. Now, robbery is a violent felony that is not on the list of expungible convictions. So that's going to permanently block any case in which it falls within the waiting period. So the 2015 case would ordinarily be waiting until 2027 to be expunged. However, the 2020 case, because it's a subsequent conviction that's ineligible for expungement, now blocks the 2015 case. Those are both permanently ineligible for expungement. But this person does have the ability to expunge the 2018 STET because there is no subsequent conviction rule on a STET. All right. So we're now going to talk about expungement of cannabis in a little bit more detail. I did preview this. Again, if the person simply wasn't convicted of the charge of cannabis possession or even possession with intent to distribute or anything, again, it doesn't matter what the charge is. You just analyze based on the rules of non-convictions. So it would be the same as any other case. If they were convicted of cannabis possession, it's immediately eligible based on more or less the new era of adult use, recreational use. If they were convicted of cannabis possession with intent to distribute, that is still a felony, but that waiting period was actually reduced to 3 years. So 3-year wait from completion of sentence. Yes. The way that you would tell that is sometimes it's listed on the charging document or the case search result. Sometimes, unfortunately, it's not. So you may have to sometimes do some research into that. Manufacturing and distribution of cannabis without the proper licensure is still a felony in Maryland, and that is still not eligible for expungement if someone was convicted of that. Now, I did also mention earlier that there may be some exceptions to the unit rule, and one of those is cannabis related. So if someone has cannabis possession convictions or charges that are part of a unit with otherwise ineligible charges, you can expunge the cannabis charges out of a case. So let's say someone had cannabis possession and armed robbery convictions in the same unit. You can expunge the cannabis charge. So that is an exception to the unit rule. Now, the courts are in the process of automatically expunging simple cannabis possession charges where that was the only charge in the case. But it's a bit of a work in progress. Still, they're mostly gone, but there's some that are occasionally showing up. And the person is still entitled to file the expungement and should do so. Now moving over to traffic cases. Traffic cases are really should be thought of as basically the same as any other case. But the only distinction is certain traffic offenses that are more minor are basically just completely removed from the expungement process altogether. So that means anything major that carries the possibility of incarceration is treated like any other crime. You can find the list of what's considered major on our website. And so all the rules would apply. If it's a non-conviction, it follows those rules. If it's a conviction, you've got to make sure it's on the list of eligible offenses and it can count as a subsequent conviction, etc. Anything minor like speeding, where you cannot go to jail for committing this offense, that's completely removed from the expungement process altogether. So it does not count as a subsequent conviction. It doesn't count as a unit rule violation. It's not going to block otherwise eligible cases from being expunged. Now, here's just a couple of additional housekeeping things to wrap up and keep in mind what when looking at expungement eligibility. The first thing here, a person cannot be a defendant in a pending criminal case. So you cannot file any expungements if you are currently facing criminal charges. Once those charges are resolved, you can file, even if the person is found guilty, even if they go to prison. If someone's serving any sort of criminal sentence, including probation, parole, that does not count as a pending criminal matter. There's sort of a misnomer of calling this the active case rule, when really it's the pending case rule. So once the charges have been disposed and a adjudication has been made on those charges, then it's no longer pending. So the person serving the sentence can file to expunge otherwise eligible cases. So that's an important distinction to keep in mind. Of course, you can't expunge the case that you're currently serving for, but potentially you could in the future. I do see a question popping up of whether or not the slides are available on the website. Yes, once this presentation is being recorded and once it is finished, the slides themselves, along with the recording, will be uploaded to our website on our volunteer resources. So moving along, important to remember that a violation of probation itself does not count as a subsequent conviction, and someone facing a VOP hearing that's pending, that does not count as a pending criminal matter. So that wouldn't prevent someone from filing expungement for other things, and there is case law to support that. Um, I will talk a little bit at the end about this Abhishek appellate decision, but as of the time of this presentation, which is April 2025, the Abhishek appellate ruling is in effect. It is good law, and it states that basically someone who violates the terms of the probation and has the probation closed unsatisfactory, it makes that case ineligible for expungement, regardless of any of the other requirements that it may meet ordinarily. This was actually overridden during the 2025 legislative session, and this rule won't apply anymore as of October 1st of this year. And I do have a slide about the details of that legislation at the end. So I'm going to talk just quickly about what it looks like to analyze a criminal record, and how we go about finding these cases. So we use Maryland Judiciary Case Search. We use the MDEC Smart Search system, which is basically a case search that is attached to Maryland Court's e-filing system. You don't actually need a login on MDEC to use Smart Search, and we do have that linked on our website as well. But you cannot actually find everything super easily on either of these sites. So we also use a third background report that we get from Westlaw, and we provide that to any volunteer who accepts a case. And then basically our recommended system is to cross-reference the Westlaw report against these two websites and determine eligibility that way. There's also a fingerprint report that anyone can get, and that is going to pretty much be the definitive criminal history report of that person in Maryland, but we do not require any clients to get that in advance simply because it does cost money, it does take time, and we don't want to put that burden to receiving legal services on our clients. But if someone wants to get it or has it and they can provide it to you, it can be very helpful. So just going over kind of digging into these to your own client's records and finding what's out there and things to be aware of. These dispositions in this first bullet point no longer appear on Maryland Case Search. So any charge that resulted in one of those three dispositions does not appear on the website. It does appear on this Smart Search that I alluded to, but it's important to remember that these cases are not expunged. They're simply hidden from that particular website. So that's why we use the Westlaw report and the Smart Search website to cross-reference everything and try to find those dropped or dismissed charges, because they still need to be expunged. Since, again, they can still appear on private third-party background checks, they can still appear on fingerprint reports, and will until they get expunged. So here's an example of a case from the Westlaw report and what it would look like. It looks similar to what a case and charging language and outcome would appear on Maryland Case Search. So you'd be looking for the date, the relevant dates of disposition, the disposition itself. In this case, this person received a stat in 2010. So that would be something where as you're going through the criminal history of the client, you could flag this right away and say, okay, I see a stat. That sort of should put a green light off in your head and say, all right, let's check the disposition date. Well, that's much longer than 3 years ago. Of course, the charge itself doesn't even matter in this instance because it's not a conviction. And so you would say, all right, that looks like an eligible case, assuming this was the only charge in that particular case. Unfortunately, we have to provide this caveat that sometimes the Westlaw court can be outdated and the case itself could already be expunged, which is why you want to take the case number, which of course is redacted here, and plug that into this Maryland Smart Search system. Plugging those case numbers into Smart Search, if they are coming up, then they still need to be expunged. And so you want to go ahead and make a petition for that case. And if it's not coming up at all in Smart Search, that most likely means that the case is already expunged. And so you don't have to worry about filing a petition. There actually is but if it's coming up on the Westlaw report, I'd suggest getting in touch with me, and there's kind of a separate process by which you can ask Westlaw to remove it from their system. The reason behind all this is that when the court orders the expungement, they're not really having the legal authority to force Westlaw as a private company from expunging the record. However, they should be removing it themselves, and they do have their own internal process to do so. So the actual filing, we do have a web tool that you can install on Google Chrome, and we have a separate training video and information on our website about how to install it and use it. So check that out. This web tool basically fills out the expungement petition, kind of just fills in the blanks. It is not a substitution for the legal analysis performed by an attorney. It's more of just a tool to quickly fill in the blanks of those PDFs for the actual legal petitions that need to be filed. When you are filing, anything that's not a conviction is free to file that petition, and then each case that is a conviction would normally be a $30 filing fee, but if you are volunteering with MVLS, you're entitled to use the automatic fee waiver that we get as a legal services corporation funded nonprofit. So this is an automatic fee waiver. It's not a request. It is just something that you certify that you are volunteering through a nonprofit agency. And so we've already pre-screened the client as being financially eligible for the services. And so they're entitled to the fee waiver. After filing, the state does review each petition and they have the opportunity to object. If they object, the court must schedule a hearing. What happens at a hearing is the state will have to give its reasons for why this person's not eligible for expungement. And of course, the court hears both sides. Sometimes the state makes an error in their calculation of eligibility, and you can defeat the objection. If it was looking like the case was simply filed in error and you missed something and the client is not eligible for expungement, you can withdraw the petition and ask to have the hearing canceled. And again, all of this stuff is something that MVLS is happy to mentor any volunteer on and help you out in the event that some of those complications do arise. So once you have filed your case, it's really just a waiting game, waiting for the court to process all that paperwork, and you're going to start seeing some documents come back to you in the mail, or also watch out for your email because some jurisdictions are now doing electronic service of these orders. So the court grants the expungement petition. It serves the state agencies that have record of that event with the expungement order. It will also mail the attorney and the petitioner the expungement order as well. So hold on to that. And then you're waiting an additional amount of time for those agencies that receive the order. They must file a certificate of compliance stating that they've expunged their version of the record. They're supposed to file that within 30 days of receiving the order. It often does take longer than that. But you are basically just want to wait until you receive orders and compliances for all the cases that you file to expunge. And you can expect that to take about 4 to 6 months from when you file with the court. So what I do with my cases is I wait until I have all those documents, and then I include those documents with my closing letter to the client. The client may well have received them already, but I just want to make sure that they have everything I'm getting for their own records. And so that is about it in terms of criminal record expungement in Maryland. That is your basic overview of eligibility and how the process works. And so closing out, like I said, with 2025 legislative updates. This is really the only major piece of expungement legislation that did pass this year, and it was Governor Moore's sponsored bill, the Expungement Reform Act of 2025. Like I said before, it overrides the Abhishek appellate decision by changing the language of the statute related to completion of sentence or satisfaction of sentence. And it makes it so that the person just has to finish out the sentence one way or the other, and then the normal waiting periods apply. So it doesn't change eligibility, it just changes that interpretation. It attempts to nullify the interpretation that the appellate court made in that case, so that violations of probation are no longer a barrier to expungement. That's going into effect October 1st, 2025. It does give the court some factors to consider where the person's success at probation and their payment or ability to pay any ordered restitution can be considered in the event of this filing. This act also adds 3 eligible convictions to the 10110 statute. Those are driving without a license, which is a major, major victory. This was something that was strangely omitted from previous expungement updates and was really blocking a lot of people from getting things expunged. It also adds cashing a bad check and using a stolen credit card. That's also going to affect October 1st, 2025. And then it's also going to hide stets from case search after the 3-year waiting period is up, as well as those offenses for cannabis that were pardoned by the governor. That's not taking place until January 31st, 2025. So it's not expunging those cases. It is hiding them from case search. So we still want to get those expunged. So I'd be happy to take any questions if there are any. I do see a Q&A come up. It says MVLS also has boilerplate for the petition. If I understand that question correctly, if you're asking about maybe agreement or sort of retainer that we enter into, maybe we do have documents of that nature that you can use, or I'm not sure if maybe you're asking about the petition itself, like the language of the petition, that is all court provided, and we do have links to that on our website, but let me know if I misunderstood the question. Yes, so the petition itself, there's different petitions, non-conviction, conviction, non-conviction less than 3 years old, and cannabis. So there's 4 separate petitions. Those are all provided by the court as just a standard template, and they are on the court's website, and they're also all linked on MVLS's website. And they all are fillable PDFs so that you can type in all of the required information to, and it basically provides check boxes where you select your reason for eligibility. Okay, so we're getting a question about what are the state agencies that have the list of records, and what about federal agencies? So as a matter of course, most courts are automatically, they sort of have a standard list of any state agencies that they serve the expungement order onto. This is typically the police, the state's attorney's office, the court clerk itself, the CJIS, Criminal Justice Information Systems, and a few others that they appear to have a comprehensive list that it automatically goes out to. So sometimes you'll get back a compliance saying, we have no record of this event, like this never went through our agency. But the courts have more or less put together a list that they use that seems to be comprehensive. I have had some courts send me as the attorney the order and ask me to fill in the agencies. So if that does happen, you should reach out to MVLS and we can help you figure out what to write in there. As far as federal agencies, the expungement does not apply to federal agencies. So the Maryland court does not have the authority to force any federal agency from expunging its own record. And we do see complications arise from this. So for example, if someone has been arrested by the federal government and now and they have a rap sheet in Maryland, the federal government may have pulled those records into its own records, and now that's just in there. And unfortunately, Maryland level expungement is not going to touch that. So there's really nothing that we can do about that, unfortunately. I'll just wait a few more seconds and see if any other questions come through. But otherwise, thank you all very much. Okay, we have another one coming through. Are expunged records required to be divulged on federal background checks? That's a really good question. So they're not required to be divulged to employers generally. There are protections for people who have expunged records. They can basically leave that blank on general job applications. However, Federal background checks, I would err on the side of caution, and I would probably advise my client to divulge that if they are going before government security clearance. What you may need to do is get certified copies of the expungement order, if possible, or at the very least, provide the expungement order if someone is going to go through that. The next question is, will we get acknowledgement or certificate of training? MVLS does not provide certificates, like CLE type of certificates. If you need an acknowledgement of any kind, I'd be more than happy to provide something in writing. So do email me. My email's on the screen if you do need something like that for your employer or anyone. Please reach out. I'd be happy to do what I can to provide something in writing there. Do subsequent convictions in other states affect Maryland cases? The way the statute is written, they technically can. So in general, my experience is most states' attorneys are not looking outside of Maryland and so aren't really considering that. But I have seen it happen. I have seen states' attorneys run nationwide background checks and consider subsequent convictions. So unfortunately, there's no good argument against that because the statute is written in such a way as it just says conviction. It doesn't say Maryland conviction. So unfortunately, yes, they can be considered subsequent convictions if they occurred outside of Maryland. Okay, and I do see another statement in the Q&A here about upcoming expungement clinics. We actually do, I should mention, we do have an upcoming expungement clinic on April 26th at Woodlawn High School. And we are still hoping to get some volunteers signed up for that. So definitely reach out to me if you are interested. It is just from 10 a.m. to 1 p.m. And if you can attend for any time in that window, we'd be happy to have you. Myself and other MVLS employees who are expungement experts will be there to mentor anyone through client consultations. Okay. Well, thank you very much to those of you who are in attendance. And again, this will be recorded. The slides will be uploaded online. Definitely take down my email address if you're interested in expungement at all. Check out our website if you're interested in volunteering for any of these other legal areas that you see on the screen now. And thank you very much.